What is transportation law? Transportation law covers most aspects of travel and commerce on the streets and highways, in the air and the water, including regulation in vehicles and vessels, implementation and safety standards, and oversight of shipping activity. Transportation is regulated at both the state or federal level with the U.S. Department of Transportation (DOT) being the main federal regulatory agency. Individual states often also have their own transportation authorities to regulate aspects of the roads and transportation hub. Still, federal agencies lead the way nationwide. Federal agencies change with regulatory and various means of transportation include the number one is air transportation via Federal Aviation Administration o pinatawag na FAA, highway transportation via Federal Highway Administration. The 3, railroad transportation via Federal Railroad Administration. And the 4, aircraft accident via Additional Transportation Safety Board. Air transportation. Air transportation responsible for the regulation and policy recommendations, government certifications, and operation aspect of air carriers and commercial operators of large aircrafts. Air agency, aircraft dispatchers, flight engineer, and flight navigators approved schools. And air carriers and airmen, airline transport of pilots, aircraft dispatchers and flight engineers, and flight navigators. It is responsible for management and oversight the National Simulator Program (NSP) and air taxi insurance certification and function. Air transportation provides recommendations, government certification and operations of air carriers and commercial operation of large aircrafts, private carriers operating for compensation of aircraft dispatchers, flight engineers, flight navigators, Part 142 Training Center, related training courses. Number 2, highway transportation by Federal Highway Administration. For the highway and public motor vehicle safety, public transportation, motor carrier safety, hazardous materials safety, rail and research technology and statistics program. 3, railroad administration via Federal Railroad Administration. Railroad Safety Areas Office of Railroad Safety promotes and regulates safety throughout the nation's railroad industry. The office executes regulatory and inspections responsibilities throughout diverse stops and railroad safety experts. The stops include 400 federal safety inspectors who operate out the 8 regions office. Each regional administrator is supported by 2 deputy regional administrators, chief inspector, supervisory specialists, grade crossing safety manager, and safety inspectors for 5 safety disciplines focusing on compliance and enforcement in hazardous materials, motive, power and equipment, operating practices, signal and training control, track. Aircrafts assigned by National Transportation Safety Board. The National Transportation Safety Board, NSTB, is a small, dependent federal agency with responsibility for investigating transportation accidents, conducting transportation safety studies, issuing safety recommendations, aiding victims' families, aviation of passenger, rail disaster, and promoting transportation safety. SB makes safety recommendation for federal real estate agency transportation provides and manufacturers which may or may not choose to implement them. In recent year, NSTB recommendations help build support for the laws enacted to maintain positive train control system. A safety technology now being installed for certain railroad lines. Federal Aviation Administration (FAA) regulations to address urgent fatigue, state law addressing distracted driving, federal safety standards for helicopter, air, ambulance, and crashworthiness standard for helicopter fuel system, which are required under the new federal law. Civil Code of Career. Article 1732. Common careers are persons, corporations, firm, or association engaged in the business of the carrying of transporting the passengers or goods are bought by land, water, and air for the conversations offering their service to the public. Article 1733. Common carriers from the nature of their business and their reasons for the public policy are bound to observe extraordinary diligence in the area of vigilance over the goods and for the safety of the passengers transported by them according to the old circumstances of each case. Article 173. For common carriers are responsible for the loss, destruction, of the variations of the goods unless seen in due any of the following causes only. 1. Flood, storm, earthquake, lightning, or other natural disaster or calamity. 2. Act of the public enemy in war, whether international or civil. 3. Act of emission of the shipper or owner of the goods. 4. Character of the goods of defects in the packing of the containers. And 5. Order or act competent public authority. Article 173. In the case other than those mentioned in the laws 1, 2, 3, 4, or 5, the preceding article is the goods are lost, destroyed, or deteriorated, common carriers and presumed to have been at fault or to have acted negligently unless they prove that they observed extraordinary diligence as required in Article 173. Articles 1736. The extraordinary responsibility of the common carrier lasts from the time the goods are unconditionally placed in the possession of the receipt by the carrier for transportation until the same are delivered actually or constructively by the carrier to have consent or to the person who has the right to receive them without prejudice to the provision of the Article 1738. 1737. The common carrier's duty to observe extraordinary diligence over the goods remains in full force and effect even when they are temporarily unloaded or stored in entrusted unless the shipper or owner has made use of the right of stoppage in the trust. Article 1738. The extraordinary liability of the common carrier continues to be operative even during the time that goods are stored in a warehouse of the carrier at the place of destination until the consignee has been advised of the arrival of the goods and has had reasonable opportunity thereafter to remove their otherwise dispose of them. Article 1739. In order that common carriers may be exempted for responsibility, the natural disaster must have been proximate and only caused the loss. However, the common carrier must be exercised due diligence to prevent or minimize loss before, during, the after the occurrence of flood, storm, or other natural disaster, in order that the common carriers may be exempted for liability for the loss, destruction, or deteriorations of the goods. The same duty incumbent after the common carriers in the case of the act of the public enemy referred in Article 1734 number 2 and Article 1740. In the common carriers negligently incurs in the delay in transporting the goods, a natural disaster shall not free such carrier from responsibility. Article 174. The shipper, the owner, merely contributed the loss, destruction, or the degradation of the goods, the proximate cause, therefore, being the negligence of the common carriers. The latter shall be liable in the damages, which, however, shall be equitably reduced. Article 1742. Even the loss, destruction, of the degradation of the goods shall be caused by the character of the goods or the faulty nature of the packing of the containers, that common carriers must exercise due diligence or forestall or lessens the loss. In Article 1743, if though the order of the public authority, the goods are seized by destroyed, the common carriers is not responsible provided said public authority had power issue the order. Article 1744 are stipulations between the common carrier and the shipper of owner limiting the liability of the former for the loss, destructions, or retardations of the goods. To disagree less than extraordinarily diligent shall be valid provided it. The writing signed by the shipper of owner. 2. Supported by the valuable consideration other than the service provided by the common carrier. And 3. Reasonable, just, and not contrary of the public policy. Article 1745. Any of the following or similar stipulations shall be considered unreasonable and unjust, contrary of the public policy. And 1. That the goods are transported at the risk of the owner or shippers. And 2. That the common carriers will not be liable for any loss, destructions, or deteriorations of the goods. And 3. That the common carriers needs not observe or any diligence in the custody of the goods, or diligence less than the good father of the family of the man who ordinary prudence in the diligence over the movables transported. 5. The common carrier shall not be responsible for the act or omission of its employee. The only common carrier's liability for acts committed by the thieves or the robbers. Why do not act with a grave irresistible threat, violence, or force, dispense without diminish. 7. That the common carriers is not responsible for the loss, destructions, or deteriorations of goods or account of the effective condition of the car, vehicle, ship, airplane, or other equipment used in the contract of the carriage. My name is John Joseph S. Bercasio from BSHM Bachelor of Science, Economic Management and Tourism.